All rise. Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. This is our tax case number 17-3, Wilbur Ellis Company et al. Versus the Department of Revenue. It's the time set for argument. Each side will have 20 minutes in which to argue its position. Appellants may reserve a portion of that time for rebuttal argument. Counsel, you need to keep track of that time for yourself. We have read the briefs and conferenced this case. We're familiar with the facts and issues presented. Would each of you, as you begin your argument, identify yourself and the party you represent? Counsel for appellants may proceed.
Thank you, Your Honor, and good morning. I am Brian LaCourte of Ballard Spahr, joined by Chase Bales, and also joined by our co-counsel, James Busby of the Kavanaugh firm. We represent the appellant, Wilbur Ellis. May it please the Court, this case comes to this Court in a rather unusual procedural posture. The tax court below erred by granting summary judgment in the context of a Rule 12c motion for judgment on the pleadings filed by the Department of Revenue. And in so doing, the tax court appears to have attempted to resolve disputed issues of fact inappropriate in either a motion for judgment on the pleadings and certainly inappropriate for a Rule 56 dispositive motion. The tax court ruled below on summary judgment that the relevant statute and exemption at issue, ARS 425061A33, and the term at issue, propagative material, does not include fertilizer and pesticides. The tax court also entered summary judgment in error that the supplemental nutrients that pass through the crops at issue and onto the consumer of the end product were not sales for resale.
Do you really want us to remand this case, or don't you want us to rule on the merits of those two claims?
Your Honor,
depends on how we would rule on those claims, right?
Of course it does. However, here's the problem that I can perceive even if this court were to rule in appellant's favor. The Department of Revenue below asked the court for 6 months to conduct discovery and the opportunity to develop a record on what it contended would be disputed facts. The court granted that motion. And, of course, our cross motion, Wilbur Ellis's cross motion below, was to start the summary judgment process, not to complete it. And so if you were to rule on this record, it's a guaranteed appeal for the Department of Revenue to the Supreme Court that there is an incomplete record and there were disputed issues of fact. In fact, the Department's briefing here in this court suggests, and I note without a cross appeal, so there's a jurisdictional question if this is even appropriate to be raised to this court, but nonetheless the Department contends here that it really did or should have received a judgment on the pleadings. And so that's a mess going up if you rule on this record. Of course, we believe the record amply supports our position on the construction of the statute, but the Department does not. The Department says rule on the face of the pleadings, and that is the fundamental error in the procedural posture in the outcome below, because there is no way to rule as Judge Whitten did, or the tax court did, on this record in connection with just the complaint.
Well, if we determine that, in fact, the court shouldn't have converted this to a summary judgment motion and should have just treated it as a ruling on the pleadings, then we could get to the merits just based on the statutory interpretation, couldn't we?
Here's the problem with the statutory interpretation. It's a mixed question of law and fact, Your Honor. The problem is this is a term, propagative material, that is not defined in the statute. It is not defined in a dictionary. It is defined in some form, as the Department contends, in an online glossary from an unreliable USDA website. It is the subject of factual inquiry. And so, yes, we believe we have presented a factual record from which, or at least makes plausible and actionable our claim.
But
Whether
there is
that
a definition in Black's Agricultural Dictionary. Don't we all have that in our offices?
Well, I don't have Black's Agricultural Dictionary. I do have Black's Law Dictionary. The problem with this term, Judge Thompson, is it is a technical one. The challenge, I should say, is it is a technical one, and it is vague. And it is in the context of commercial agriculture. This isn't just planting seeds in a pot in the patio to grow tomatoes. This is agribusiness. And the problem with understanding this term in the context of the propagative plant parts that are listed in the statute in the context of commercial agriculture is underscored by the error the tax court made and the department made with regard to citing spores, that the function of growing mushrooms, as an example of what's not enumerated in the list. Mushroom spores relate to fungiculture, growing mushrooms, farming, forest farming. Fungiculture is not enumerated in the statute as one of the agricultural, horticultural areas that is concerned with this description of exempt propagative plant parts and material.
Well, before we get further into the merits, shouldn't we view this as, we would review it to determine whether or not the trial court properly determined this by ruling on the pleadings? And if we find that he could rule on the pleadings, then we can go to the merits to the extent that it's available. But otherwise, if we determine that he could not rule on the pleadings, given the posture, wouldn't we have to remand it back for him to entertain the summary judgment motions?
You would, Your Honor, and that's the fundamental problem, is that we have an incomplete record in this appeal. One side says it's complete.
Incomplete in that the department didn't have a chance to complete the record. I believe you stated to Judge Whitten that you'd given him, quote, your best. So your client had presented all the evidence on the issue before the tax court. Isn't that correct, counsel?
Well, Your Honor, in fairness, I did say we gave our best shot, and in that oral argument, it was an attempt to try to address the motion for judgment on the pleadings, and that the Department of Revenue appeared to give its best shot by suggesting an online glossary was determinative, and it wasn't. But in fairness, Your Honor, the reply brief to the motion for judgment on the pleadings that the department filed was directed to Rule 12C, judgment on the pleadings. And it did go outside the pleadings and challenge what sources of information should be available, but that created factual issues. And then they filed a Rule 56D motion requesting 6 months of discovery to dispute our facts. So it is an incomplete record in this regard. The record has our side of the story, and the department, even if it's briefing, now adding more definitions and more external extrinsic evidence, disputing our positions. That's the problem here, is you're effectively sitting as a trial court in these appellate proceedings determining what is the best source on the merits to construe this statute based on technical sources, whether it's experts or an agricultural dictionary. So the remand question, unfortunately, this is like an interlocutory appeal. This should be remanded at a minimum, understanding that the tax court has some preconceived notions about what propagative materials are, but the tax court made some judgments about an expert that are just wrong based on an unvetted, incomplete record. So it's an example of leaping or prematurely reaching factual conclusions without the complete summary judgment briefing. So just as one example, the spore issue on the merits, that's just wrong. It's an error. But that didn't come up until the department's reply brief. And so the tax court made essentially a conclusion of fact that was wrong, that would have been disputed had the summary judgment process been completed. We would have controverted that position and pointed out the problem in the error. That's compounded by the department's appeal here.
Did you bring that to the court's attention during your oral argument when there was oral argument? We'll leave it at that.
We did object to additional material and basis coming into the court in a reply brief. And in the oral argument, we, frankly, and I think the Department of Revenue was the same, we were preparing to address the pleadings. This is supposed to be an oral argument on the Rule 12 motion for judgment on the pleadings, because the tax court granted the Department of Revenue 6 months to determine what factual record they wanted to present and to do discovery, present their own expert, and respond to our summary judgment motion. So that morning at the oral argument, in fairness, we were both prepared to address, did our complaint state a claim for relief, a cause of action? And it did. And so when the court said at the beginning of the hearing, I'm going to go ahead and treat the Department of Revenue's MJOP as a summary judgment motion, because it did go outside the pleadings. The problem is the department hadn't fully briefed those issues, and we hadn't even addressed the factual issues before the court. So you have, in essence, an incomplete summary judgment decision that's wrong because it lacks the complete record. And yes, in a perfect world, we'd say you have enough to decide, at least on our record, what is or is not propagative material. But the problem is the Department of Revenue's positions clouded that issue by raising 20 synonymous terms that are technical and would require some expert analysis or at least some industry analysis. You know, the context of this statute is important. This is not just an academic exercise. This is about commercial farming in Arizona. The legislature passed this law from an original exclusion of fertilizer and exempting seeds to broadening that exemption to include all sorts of plant parts, removing the exclusion of fertilizer, and referencing propagative material as sort of a catch-all together with the exhaustive enumerated list of plant parts. The legislature didn't say, and other plant parts or other propagation plants. It said, and other propagative material. Well, that raises a whole host of factual issues that we need to address, and the tax court didn't get there. It leaped too far ahead, and now we have this record. So, Your Honor, you can only say that in trying to interpret this correctly in the context of aiding in economic development for commercial farmers in Arizona, the court ought to have the facts right. And the facts here are one-sided and disputed in a way that makes this record difficult to respond to in an MJOP context. And so that's a fundamental problem. Should the case be remanded? At a minimum, it should. I'd like to talk about the sale for resale issue as well. There again, the Arizona tax court erred in making a decision or weighing factual information and allegations that were disputed by the Department of Revenue. The court is, of course, familiar with nutritional supplements in crops to create superfoods, enriched vegetables, calcium-enriched milk, enriched livestock feed. The record is substantial below that those enriched custom blended fertilizers to create those superfoods or enriched livestock feed are specifically designed for those nutrients to pass through to the end product, the crop, and that those end products then contain intact those nutrients. They're not metabolized. The tax court fumbled that issue. It just disregarded it. And so,
has there been any other jurisdictions that have adopted this theory?
This case is a first impression here, and there are other cases that have noted that propagation or propagative materials include manure, compost, soil conditioners, etc.
I'm talking about the sale for resale.
This is, again, a case of first impression. There are jurisdictions that legislate in this regard, but we don't have a case on point from another jurisdiction that says a crop is not a sale for resale directly in regard to this issue of whether the nutrients that pass along through the end product as a superfood are a sale for resale. It's a case of first impression in that regard. There is law that is not favorable in regard to farming and agriculture in the context of sale for resale, but our regulation here isn't that narrow. The question, as the Supreme Court has noted in Duhame, is does the component part remain intact through to the end product as a intact component part? The component constituent, is it absorbed? Is it consumed by the product that is made, in here grown, or is it intact? And that's at least a fact issue, Judge Marcaretti. I mean, it's one that the court did not address, and it's disputed. So here again, at least a remand would allow us to build a record on that beyond an MJOP. I have about 5 minutes and 30 seconds. If I may, I'd like to reserve that remaining time for rebuttal. Thank you.
Scott Teasdale with the Arizona Attorney General's Office, representing the Arizona Department of Revenue. May it please the court. Regardless of whether the procedural posture is unusual in this case, whether this be ruled on as a motion for judgment on the pleadings under Rule 12C or a motion for summary judgment under Rule 56, the core legal issues are all the same. Namely, does the propagative materials phrasing in 425061A33 exempt fertilizers and pesticides? Clearly, it does not on its face. The exemption, as we've all read, exempts proceeds from the sales of seeds, seedlings, roots, bulbs, cuttings, and other propagative material to persons who use those items to commercially produce agricultural, horticultural, viticultural, or floricultural crops in this state. Fertilizers and pesticides are not other propagative materials. Every enumerated item there is a plant part from which a new plant is grown. If the legislature had wanted to exempt fertilizers and pesticides, it could have simply said that it was exempting fertilizers and pesticides, or it could have simply exempted supplies used and consumed in the business of commercial farming or some similar formulation.
Are the list of plant materials, is that all inclusive?
Not at all. And in fact, if we look at simply the USDA glossary defining propagation materials, it says it is a plant part such as a bud, tuber, root, or shoot used to reproduce, open paren, propagate, close paren, an individual plant vegetatively. Now, there are items right on that one list that are not included in the statute, and I think that's dispositive of the claim that the listing of individual plant parts was somehow dispositive. And again, it goes back to, I think, a common sense reading. If you were in the legislature and you decided you wanted to exempt all supplies consumed in agricultural production, or if you wanted to exempt fertilizer and pesticides, would this be the phrasing you would use? It doesn't make sense. It also doesn't make sense because Arizona has been taxing these things for decades after decade after decade. And the notion that all of a sudden this taxpayer paying millions of dollars in tax every year, being just one retailer of these products, all of a sudden discovers that, oh wait, these are propagative materials. Why have we been paying these millions of dollars in tax? It's ludicrous on its face. Now, the sale for resale. A farmer that puts fertilizer on his land is not reselling fertilizer. He is using and consuming fertilizer as a supply in his business. In fact, if putting fertilizer on your land is not a use and consumption of fertilizer, what would be? How else could you use or consume fertilizer? Under their theory, it's never used and consumed because, as Judge Witten, tax court put it, they're doing a trace the elements analysis. And what Judge Whitten seemed to do is say, even if I accept that as true and don't even give the department a chance to investigate that, and I don't know whether that's true or not, I'm not a microbiologist, but even if it's true, that is not a sale for resale. Initially, under 425022, the plaintiffs bear the proof of showing that a sale is not at retail. Under 425023, all proceeds of a retailer or all proceeds that are taxable of a business doing business in a classification are deemed to be taxable. The burden is on them to establish this, and it is simply incorrect. Our regulation, AAC R155123, sets forth the basic rule of taxation of business consumption of supplies. And it reads, the sale of tools, supplies, and other articles to be used or consumed by persons in the operation of their businesses and not for resale are taxable at retail sales. All right. Even under manufacturing, where raw materials are deemed to be purchased for resale under AAC R155122, the last sentence reads, supplies which are consumed in the manufacturing process do not qualify. Okay. Arizona, like every other state that has a similar tax or a sales type tax, does tax significant amounts of business consumption. When a Home Depot buys its cash register to use in its business, that is taxable. This is not like a corporate income tax where you start with the gross and you deduct all the business expenses to come up with a net and only tax the net. The transaction privilege tax is a tax on the gross revenue of a business doing business in a taxable classification, and only if the taxpayer proves up a specifically applicable exemption, and obviously there are many of them in 425061, or if the taxpayer is doing a non-taxable separate line of business under, say, the Holmes and Narver analysis, are proceeds not taxed.
In the sale for resale context, are there any other states that have ruled on this particular issue as raised by the appellants that you're aware of?
We cited a few cases that discussed. Let me see if I have them in my notes. We cited, I think it was an Illinois case in our reply brief that analogized fertilizer to seeds in holding that seeds were not purchased for resale because they were consumed, and they analogized that to fertilizer. And one other case, I can't remember the state, in which they essentially said that the fertilizer became part of the real property when it was spread on the real property. Those are the only cases that I am aware of. The taxpayers are correct. I've done some research that a lot of other states do have specific exemptions for fertilizer. But what they have that we don't have are either supply exemptions, where all supplies used in a particular exempting process would be exempted, or they specifically mention fertilizer. And again, the legislature is the master here, because they have to decide what they're going to tax and what they're going to exempt. And whenever these issues come up, as much as they might like to give an exemption for something, they have to determine how to pay for it. And these issues are really best considered at the political level. Our legislature is not shy about creating exemptions when they think they can. And I would refer any taxpayer that is disgruntled because they think Arizona businesses are being disadvantaged, that needs to go to the legislature and not to the courts to infer an exemption that is clearly not in existence currently. I would point out, and I'm certainly, I have not tried to read every statute and every regulation from every state that has a sales tax to determine how they're handling fertilizers and pesticides. And I don't think it's really relevant, since the fact that an express exemption can be created by a legislature is of course obvious. But if we look just at the California sales and use tax law in their code section 6358, they exempt, among other things, fertilizer to be applied to the land, the products of which are to be used as food for human consumption or are to be sold in the regular course of business. That's how a legislature does it if they want to exempt fertilizer. They actually do it. In this case, we have someone coming in saying essentially everything the farmer buys that helps plants to grow is propagative materials. Well, I don't think that's at all suggested by the language of the statute. Additionally, while I think the conversion of the 12C motion was improvident, whether this is ruled on as a 12C motion or a 56, essentially you get back to the same inquiry. You have to interpret these words. We've given our interpretation. They're suggesting, oh, it's a factual issue because we've hired someone who's going to say, other propagative materials, in my opinion, means something else. Well, typically the courts don't entertain testimony of legislators saying what they meant in words. They simply look at the statute and make the interpretation as a matter of law.
Well, and looking at the language of the statute, as you've previously read, the sale of seeds, seedlings, roots, bulbs, cuttings, and other propagative material, and just looking at the words that the legislature enacted, other propagative material, when I referenced reading law, I think it was cited by Appellant's Counsel in their briefing, that treatise is instructive to say that when you use the word other, you should insert similar before the word other. So according to that legislative treatise in terms of interpreting the statute, it would read cuttings and other similar propagative materials. So that would inure to your benefit, if I'm correct, Mr. Teasdale, that it would lead us back to materials that are similar to seeds, seedlings, roots, bulbs, cuttings, and definitely exclude fertilizer. Would you agree with me on that?
I would agree with you entirely. I think that is the correct canon of construction. When you use other, is you look for things that are similar. It does not mean everything the farmer needs. It doesn't mean tractors. There's actually a separate exemption for tractors and other agricultural implements that are purchased in the retail classification. It doesn't mean everything you do. It doesn't mean everything that goes into the plant. Now, getting back to sale for resale, they've disclaimed that pesticides would apply, but on their same trace the elements theory, if there are pesticide residues on a crop when it's sold, then the person who purchases the crop is purchasing the pesticide, and that is a sale for resale.
People don't buy corn hoping it's laced with DDT.
Well, hoping that's true. whether you get it or not. In fact,
what about the notion that you may buy a particular, I don't know, grain, whatever, with the idea that it's going to be enriched with a particular element that would be beneficial?
Well, they analogized it to animal feeds that are enriched with various things, but we have a specific exemption the legislature created for animal feed, and they chose not to do that. But to the extent fertilizer goes into a plant, I would certainly assume somehow it has to go into a plant. It's not an inert thing, or it wouldn't have any biological effect. That doesn't, I think, take scientific testimony to assume, whether it retains exactly its chemical formulation, I don't know. But one thing to consider here is the legislature is creating a tax code, okay? It's got to be interpreted by the Department of Revenue, and the Department of Revenue is not tasked, in our view, to start laying on PhDs in various technical fields in order to determine a tax issue. This is not a microbiology test. This is a tax issue. And additionally, retailers have to determine whether something is taxable. That's why we get back to the basic canons of construction. laws that impose taxes are narrowly interpreted against the state, and if something's not clearly within the tax, it's not taxed. However, with exemptions and deductions, there's sort of a yin and yang. The presumptions are reversed, and deductions and exemptions and credits are narrowly interpreted against taxpayers. And if it's not clear on its face, they're not within the deduction, exemption, or credit. And I would point out, yes, you're right, people aren't hoping to get pesticide residues, but Section 408 of the Federal Food, Drug, and Cosmetic Act authorizes EPA to set tolerances or maximum residue limits for pesticide residues on food. So there are often pesticide residues on food. And again, if you're doing a trace the elements theory, as they are doing with fertilizer, that is being transferred to the consumer in some small amount. Now, I did want to comment briefly. They've raised in footnote an issue about seeds. As you know, I brought a 12C motion for judgment on the pleadings, addressing the two issues they raised in their complaint and notice of appeal from the Department of Revenue: fertilizers and pesticides. Nowhere does their complaint mention seeds. If I had brought that up, that would have been extraneous materials, and it wasn't in their appeal anyway, so it wasn't something I was going to address. They then brought that up in a motion for summary judgment, to which I didn't respond. You've certainly seen the procedural history here. They then appeal after judgments entered on the fertilizer and pesticide issue, and in their two issues, they mention fertilizers and pesticides and nowhere mention seeds. And then they mention in their footnotes, well, the department must have conceded on seeds. No, we haven't conceded everything. It simply wasn't before the tax court, and it's not properly before this court. It wasn't part of their appeal from the Department of Revenue. So I don't think this court
Was it raised at the Department of Revenue?
It was raised at the Department of Revenue, but not in the appeal. And the seeds have other issues, obviously, if they establish the other elements under A33, but there were some other elements there, and they did not raise them on this appeal. So whether that is inadvertence or what, we haven't had a chance to address that, and those would have been factual issues if they had raised it in their complaint. But clearly I couldn't address seeds in a 12C motion, and I didn't even know they were placing them at issue until I got this cross motion where they did raise the seeds in brief. In discussing whether something is used or consumed as opposed to resold, I think that the use tax can be instructive. The use tax is, of course, a complementary tax that applies when someone has not paid transaction privilege tax on something, such as if someone purchased fertilizer out of state and brought it in. And that tax is imposed on the storage, use, or consumption of tangible personal property in this state. And if you look at it, the tax imposed by this section in 425155B says it applies to any purchaser which purchased tangible personal property for resale but subsequently uses and consumes it. I mean, there's a difference between holding something for resale and using and consuming it. We all, I think, are familiar with what it looks like to purchase things at retail. We do it all the time. When someone buys something for resale, they are not buying it to use. They're buying it to hold for resale. That is not the same thing. You know, if Home Depot buys cleaning supplies to clean their floor, that's a use, and they've got to pay tax on that, unless there is another specific exemption. And I think actually there's a janitorial exemption, so maybe that's an inapt analogy. But there is a difference between use and holding for resale. Now, I think it's important to note that there's a lot of money at issue in this case. This is not just some fell through the cracks new issue where something may have been taxed now that wasn't being taxed before, or some small thing that we can assume the legislature wouldn't have awareness of. This is an $8 million refund. Annualizing that out for the post-refund period, this one taxpayer, you're talking about $15 million. And they want you to infer exemptions that are not clearly applicable and blow a massive hole in the budget just for refund exposure, not even considering the lost revenue going forward. Okay. If they want to achieve that end, they need to go to the legislature, and the legislature needs to do what they do. And what they do is they say, how are we going to pay for this? I watch the hearings when they're considering new tax legislation and someone wants a break. Very often they will work something out and figure it out, but they have to answer that question. How are we going to pay for this? And that is why these issues are best committed to the legislature and not to the courts. Thank you, Your Honor.
Thank you, counsel.
If you have your pen here. Judge McMurdy, I'll address a question that you asked. Was the issue of seeds raised below at the department level? It was. The department denied the entire refund claim. The entire refund denial was appealed. Here is the problem that we have in this procedural context. Because the department filed a Rule 12C motion that the tax court then treated entirely as a dispositive motion, it's as if asking the taxpayer to prove everything in the complaint. And the statement by counsel a moment ago that it doesn't really matter if it's Rule 12 or Rule 56, either one works. Well, of course, if you adopt their view. But in the Rule 12 context, the issue, the standard the court applies, are the pleadings sufficient? Do they state a claim? Do you have a cause of action?
Did you raise the seed claim in your complaint?
We did notice pleading, Your Honor. We appealed the entirety of the refund claim and alleged that, in part at least, the error was the focus of that claim was that the hearing officer misinterpreted the statute.
So when they filed their motion for judgment on the pleadings, did you point out in your response that the seed claim didn't fit within the categories that they requested?
We did. We filed a
If I go read your response, it's going to be there.
Your Honor, I'm trying to answer your question. We filed a simultaneous cross motion for summary judgment and raised the seed issue in that motion. And that wasn't resolved because the court did not allow full briefing and vetting that motion. And so it is a lingering issue below. And the point is that in a notice pleading, do you have to have every single, allegation regarding the erroneous nature of the claim? We don't think so, at least not for purposes of a Rule 12 motion. But more importantly, Your Honor, the panel asked, do other states handle this, and are there any dispositive decisions? We know that of the 50 states, 2 don't exclude fertilizer. Arizona is one of them. And we know that in 1992, the legislature did try to do something significant, held hearings and changed the statute. And it changed the statute from exempting just seeds, and seeds alone, just that word, to a full, broad range of plant parts, and other propagative material. And Judge Bean, I would answer the question you raised this way. It does not say and other similar propagative material. It says and other propagative material. The word and in the context of this phrase is an alternative. It is to join other propagative material with a fully enumerated list of plant parts. And the court could say, as you asked Judge McMurdy, well, is this an exhaustive list? That's a fact issue. We have an expert witness who says it is an exhaustive list. We have the director of the Department of Agriculture who says propagative material was meant to include fertilizer. That's how this agency administers it. We have cases we've cited where propagation materials are considered things like manure and compost. And so there is, at a minimum, a factual record here, a monumental one, that the court simply ignored in deciding propagative materials has to be a plant part, or that plant part list is exhaustive. And in ruling that it was exhaustive, the tax court erred because it went down the rabbit hole of mushroom spores, which is not a correct, botanically not a correct statement. And so that's the point of why a factual record is important here. Your Honor, the statute is to be construed strictly. We don't differ or quarrel with the Department of Revenue's statement of the basic principle of law, but over the course of my career, I've argued several issues on their side and my side for what is a tax exemption and whether it's strictly construed or not. While it's strictly construed, you don't interpret out the purpose. The strict construction has to be tempered, as we've cited the case law holding to this effect, the purpose to affect the legislative purpose. And as pointed out,
the legislative purpose is in the words. That's what I'm looking to, is to the words that were used. And the words that were used, we've already said, talks about seeds, seedlings, roots, bulbs, cuttings, and other propagative material. That's what I'm bound by. The purpose, if I can read that clearly from the words, that's what I'm going to enforce. And again, going back to the reading law treatise that you cited, it says that principle, that Latin principle, implies that the addition of similar is after the word other. And so it goes back to other similar propagative materials. And that, in my opinion, unless you can convince me otherwise, doesn't seem to include fertilizers. So help me there.
Sure, Your Honor. I'd answer it this way. Adjustum generis clearly states, the case law both sides have cited, when the enumerated items are a full range, a full list, an exhaustive list, as the treatise we cited points out, then the add-on term is to be construed generally. That is the case here. The add-on term and other propagative material follows a fully enumerated list of plant parts. There are synonyms to a seedling, like a shoot. There are synonyms to a bulb, but the plant parts are exhaustive. We have a PhD. We have a director of an agency. We have evidence that that's an exhaustive list. And so that may be a fact issue, but at a minimum, if that list is fully enumerating plant parts, the fact that the phrase and other propagative, IVE, an adjective modifying material, any matter, the fact that that broad phrase is the catch-all, especially in light of the fact that the legislature added to seeds other plant parts, presents a plausible claim, Your Honor. I'm not saying that we don't need a record on this, but the words, and particularly this technical term...
Does fertilizer propagate?
It's propagative.
But that's not my question. Answer my question, please.
Yes, the expert that we presented said propagation...
What's your definition of propagation again, I guess is my question.
Okay. The definition proffered regarding propagation is the planting and growing of crops through maturity. That's propagation. Propagation is not merely planting, Your Honor. It's growing crops. And so to suggest that a seed in and of itself will propagate, it's possible, but for propagation, the growing of crops to occur, you need soil, water, fertilizer, pesticide, and seeds.
So your water use could be exempted here?
That's not an issue. And
It's my question, though.
it could be.
Soils, herbicides, those are all would now be exempt under this statute?
Well, Your Honor, the point is, what is propagative materials? And what is...
And that's what I'm trying to get to. So would water, soils, and herbicides, in your opinion, be something that would be exempt under your reading of the statute?
Yes.
Okay.
And for this reason, the word propagative isn't limited to a plant part. And it's not the catch-all that the department is suggesting that everything that might be used. Our suggestion is it is critical, and this is what the record discloses, it is critical for fertilizer. And crops do not grow to maturity we're talking about commercial agriculture here. We're not talking about planting a garden in the back of the house. So it is critical that fertilizer and pesticides are part of the process. You cannot propagate effectively in commercial agriculture without it. And so to suggest that it's not part of the process is simply inaccurate.
Thank you, Counsel.
Thank you, Your Honor. Appreciate your time. Thank you very much.
Thank you, counsel, for your arguments. We will take the matter under advisement and issue our decision in due course. Court's adjourned.